Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 112 of the NCDWI Guy podcast. On today's episode, we are talking generally about a couple of practice points for arguing that reasonable articulable suspicion does not exist in your case, that the state has not met the burden of reasonable articulable suspicion. I think you're going to find both of these practice points to be very obvious to some extent, but also I believe are very underutilized by the defense and have legal support. So this is something that really can apply across the board, regardless of the basis for the stop, no matter what the reason is for the stop. If the state is trying to articulate reasonable articulable suspicion, the officer does not see a specific traffic violation that has occurred, but is basically looking at the driving of your client, and again can't find that there was an actual traffic violation that occurred, but thinks, well, maybe this driving is unusual, or maybe there is something about this driving that leads me to believe this that your client's impaired. These are some very specific ways to attack that position. So let's just do a brief overview, and then we'll dive into each of these two ways that you can attack reasonable articulable suspicion in most cases where that is an issue. First of all, in terms of reasonable articulable suspicion, let's just make sure that we're all on the same page. Whenever we're arguing reasonable articulable suspicion to the court, we always want to begin with what the standard is for the court in finding reasonable articulable suspicion. So let's make sure we're on the same page. What the court is trying to determine is whether or not reasonable articulable suspicion of criminal activity being afoot is present. This is the law in North Carolina. Reasonable suspicion is a less demanding standard than probable cause and requires a showing considerably less than preponderance of evidence. The stop must be based on specific and articulable facts, as well as the rational inferences from those facts as viewed through the eyes of a reasonable, cautious officer guided by his training and experience. A court must consider the totality of the circumstances in determining whether a reasonable suspicion existed. So that's the kind of framework for reasonable articulable suspicion. So let's kind of take a look at whether or not the officer, the state, can meet that standard. So first attack point is the stop premature? Is the stop premature? This is something that I think can be used a lot by the defense in reasonable articulable suspicion arguments, and we, I believe, grossly underutilize this general attack point. So is the stop premature? The National Highway Traffic Safety Administration, in its 24-hour standardized field sobriety testing course, in the participant manual, goes through each of the phases of a DWI investigation. And phase one is the vehicle in motion phase. This phase of the investigation is covered in session 5. If you're looking at the participant manual, this is covered in session 5 of that curriculum. And so what is the question? Each of the phases has a specific question that the officer is trying to answer. If the answer is no to any of these questions, basically the investigation or look into criminal activity stops by the officer. If the answer is yes, then the officer either moves on to the next phase or ultimately makes an arrest. So the question for the officer at the end of phase one or in phase one is, should I stop the vehicle? So phase one is the vehicle in motion, watching the vehicle in motion. And the question that the officer has to answer is, should I stop the vehicle? So I'm just going to read from session 5 for just a moment. This is page 4 of session 5. If this initial observation discloses vehicle maneuvers or human behaviors that may be associated with impairment, you may develop an initial suspicion of DWI. Based upon this initial observation of the vehicle in motion, you must decide whether there is a reasonable suspicion to stop the vehicle. At this point, you have 3 choices. This is the crucial language. Okay, this is the crucial language, page 4, session 5. At this point, you have 3 choices. Stop the vehicle, continue to observe the vehicle. I'm going to emphasize that second one, continue to observe the vehicle, or disregard the vehicle. On page 6, on page 5. So we were just reading from page 4, continuing on to page 5. Alternatives to stopping the vehicle include 1, delaying the stop or no stop decision in order to continue observing the vehicle, or disregard the vehicle. So here's the deal. On both page 4 and page 5, I think most of us think when an officer is kind of at that stop decision, what we get stuck in when we're arguing this in court is the state is sitting there arguing, this is reasonable articulable suspicion, therefore the officer is justified. We're sitting there arguing, no, this wasn't reasonable articulable suspicion. It wasn't justified. And what I think the judge feels a lot of times is that the officer had only 2 choices. And this isn't based on the evidence, but I think that this is the mindset of the judge. The officer has 2 choices in this particular context. They can either stop the vehicle or decide to disregard the vehicle. Stop the vehicle or decide to disregard the vehicle. And that's where the judge's mindset is. And so they're trying to think, well, is this enough to justify the stop, or should the officer have disregarded? There is a third alternative, and one that is not argued enough by the defense because it's a safeguard alternative. It is a cautious alternative, right? We've heard that this is a cautious officer, right? A reasonable, cautious officer. That is the standard for reasonable suspicion that I just read. This is from, multiple cases. Anytime you look at a case that is deciding reasonable suspicion, they're going to have all of this kind of like general framework language at the beginning of the opinion. So I'm not even going to tell you which opinion this comes from because it's basically in every opinion. So if you want to find this language, go look at any reasonable suspicion issue. Here's the language from that will be in every case. The stop must be based on specific and articulable facts, as well as rational inferences from those facts as viewed through the eyes of a reasonable, cautious officer guided by his experience and training. Emphasize that cautious officer, because what the NHTSA manual says is that a cautious officer, instead of prematurely stopping the vehicle, could have continued to observe the vehicle. Okay. So this language from NHTSA, you can get the officer to talk about that during the reasonable suspicion hearing. You can present the manual. You can talk to him about it. You can say, hey, did you realize, or no, not did you realize, were you trained during your investigation of DWI training that you are supposed to follow a vehicle decide whether or not you should stop the vehicle, continue to follow it, or disregard it. And you could have continued to follow it in this case, right? So if you have a situation, a stop situation where your client is pulled over in a short period of time, right? The officer, the dash cam shows, or the officer testifies, I followed this individual for a half of a mile, or I saw them pull out of the parking lot, XYZ. I saw XYZ, and I immediately pulled them over. If there's an immediacy to the pullover without a specific statutory violation that is observed, so they're going down this road of just reasonable suspicion, no specific statutory violation, then argue that premature stop. The mindset or the reasoning in the NHTSA manual is explained very well in a concurring opinion in State versus Foreman. So this is 351 NC 627, a 2000 case. This was a avoiding a checkpoint case. So avoiding a checkpoint case. And really the facts of the case are not important. For our purposes today, the reason the majority decided what it decided is not important, but argue this in a reasonable suspicion case if you have a premature stop. This is from the concurring opinion of Justice Fry. So what Justice Fry says is that this is from his concurring opinion. There is a difference between stopping a vehicle and simply following it. Reasonable and articulable suspicion is necessary for an investigatory stop, but unnecessary to justify following a vehicle. That's the language that you need to read. Okay, so just read that language. Again, you don't necessarily need to say, if you are in and avoiding a checkpoint case and that's the basis for the reasonable articulable suspicion, then maybe that case, in fact, substantively is on point. But that dicta from the Foreman opinion is extremely helpful in arguing this specific point, which is to say that the officer is not stuck with this decision in a lot of stop cases, is not stuck with this decision of, do I stop or do I not stop? And that's what the judge's mindset a lot of times in these cases is. Do I stop or do I not stop? There's an alternative. There's a third alternative, which is, why don't I just follow the vehicle and see what I can continue to see? So when you argue this, just say, nothing preventing the officer from continuing to follow the vehicle to see if reasonable articulable suspicion existed. Make that point. We're not making that point enough on the defense end, and it's a justifiable point. It's in the officer's own training. If they've gone through the NHTSA training, it's in case law. So make sure that you are making that point, that we're not missing this opportunity to call to the judge's attention that they could have continued to follow the vehicle. Great officers that I have seen will, before activating blue lights. So, a lot of the dash cameras are on timers such that when the officer activates the blue lights, about 2 minutes in time is pre-recorded. And it just depends on the software that each patrol vehicle is utilizing in terms of how far back it pre-records. Maybe some of them don't pre-record at all. It just goes from the time of blue lights. Maybe for some it's 30 seconds, but I've kind of seen a lot of agencies that have cameras that will record for about a 2-minute time frame from the point that blue lights are activated backwards. So basically you'll see about 2 minutes prior to the blue lights coming on. However, for most dash cameras, the camera can just be turned on manually. So there's been a couple of times where officers have done a really good job and, but have been very, very smart about this. They've turned on the camera manually and then just followed my client's car sometimes for, 5 miles. I mean, for a long way. And you see all kinds of craziness that is happening during that time frame. This is, I think, a really good move by experienced officers, because you can't use this argument in that situation. They basically are showing, hey, look, here's the 6 traffic violations that I saw during this 5-mile stretch. So again, on the flip side of that, you have a number of officers that are really not doing that and prematurely stopping the vehicle. So again, general issue number 1 to bring up in reasonable suspicion cases is, was the stop premature? Second big issue to bring up, second general issue to bring up is, does your client's driving fall within what is considered the range of normal driving behavior? Normal driving behavior. So there is a laundry list of cases that have used this language to basically find that there was no reasonable suspicion, that as part of their explanation for why there's no reasonable suspicion, they are arguing that there was normal driving behavior. So I'm just going to cite a couple of those cases. State versus Robertson, 163 NC App 129, a 2004 Court of Appeals case. State versus Peel, 675 Southeastern 2nd, 682, a 2009 North Carolina Court of Appeals case, and then State versus Derbyshire, 745 Southeastern 2nd, 886, 2013 case. Those are not the only cases that have used this language, but again, I think it's important to really point out and explain to the court that this has been repeatedly upheld as a good line of reasoning for reasonable suspicion cases. The Court of Appeals in these cases and in others has looked at the kind of what's going on, what is going on driving wise in deciding whether or not there is a basis for the stop. The court in State versus Robertson said that the driving, quote, fell within or was conduct falling within the broad range of what can be described as normal driving behavior. Of course, an officer may draw reasonable inferences from the facts in his possession, and those inferences may be informed by the officer's experience and law enforcement training. In this case, the officer relied upon his prior training, which suggested that 40% of all people who make a delayed response to a traffic signal are driving while under the influence of alcohol, which is from the NHTSA manual, from the NHTSA driving clues. But the court went on to say, however, such inferences must still be evaluated against the backdrop of everyday driving experience. It is self-evident that motorists often pause at a stop sign or a traffic light when their attention is distracted or preoccupied by outside influences. Moreover, the fact that the stop occurred in the early morning hours does not enhance the suspicious nature of the observation. So again, the court has frequently repeated that language of conduct falling within the broad range of normal driving behavior. If you have a reasonable suspicion stop that is, again, not based on a specific statutory violation, but just on the officers getting up on the stand and presenting his observations and saying, although I didn't see any type of traffic violation per se, these signs of driving indicated to me that this person was potentially impaired, or that there might be something, that there was some sort of criminal activity that might be afoot. However, they are explaining that from the stand. Take that same information and talk about how this driving that was observed falls within the broad range of normal driving behavior. We are not utilizing that language that has been repeated in different types of cases, weaving cases, obviously the stop sign or traffic signal case, different types of cases. The court has used this type of reasoning that the conduct of the defendant fell within what can be described as being within the normal range of driving behavior. Argue that your client's driving is within that normal range of driving behavior for whatever reason, that we see driving like this all the time, Judge, or at this particular location. This is what normally happens, or pull that out of the officer in terms of other times that they may have seen similar driving behavior. So again, just two broad attack points that can be used, without getting into the nitty gritty. And we'll hopefully have some time, not too far down the road, to go through some of these specific, reasonable, articulable suspicion issues, specific cases that kind of speak to very, very specific types of driving that the court would look at in terms of being within reasonable, articulable suspicion. But in terms of general arguments, if you can argue to the judge that the stop was premature, reasonable, articulable suspicion didn't exist, Judge, and he didn't have to just abandon pursuit, he could have continued to follow my client to see if he could get to reasonable, articulable suspicion. And number two, that my client's conduct fell within the broad range of what can be described as normal driving behavior. Make sure that you are articulating both of those general points in addition to any kind of specific attack points that you may have based on case law or otherwise when you're making this type of motion. Hope this information was helpful and look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.